We are back with another live. Well, actually, this one is pre-recorded this time. For those of you who don't know, I am Dave, 10-year intellectual property attorney, dealing with everything from patents, copyrights, trademarks, as well as trade secrets. Please hit that like button for the YouTube algorithm, as well as hit the subscribe button if you haven't subscribed already to be a part of kind of what we have going on in the community. We do a lot of different things. I just finished up some Shark Tank reaction videos. I bring on guests who've built the business, and we talk about how they have protected their intellectual property and their journey in terms of building a business. Yeah, we do current events as well as we do these kind of live shows. That is that what we're doing today. Now, like I said, even though this is not typically I do these live, however, this one it is going to be pre-recorded. You know, Easter this weekend, man, so I got to make the travels. I'm in the Detroit metro area, but I have family all over, so by the time this comes out on Sunday, at the original time, 7 p.m. Eastern Standard Time, I'll most likely be in the car coming back to the house. So I decided to pre-record this out instead of just kind of doing none. That was the two choices. Like, okay, do I give them a break this week, or do I pre-record this and still give them something, some valuable insight, kind of let them know what's going on the IP landscape across the country, across the world, really, this week. And I decided, hey, man, I still got to get the people what they're looking for, what they want, and give them that information. So that's kind of what we're doing here. So we have a lot to talk about here, man. Bill Belichick and this young thing. Then maybe they kind of poking jabs at the New England Patriots in regard to trying to get some trademarks back from them. We're talking about Migos and his copyright situation that he has found himself in. Dumplings, a Korea company, seems like they patented a dumpling. That's new. Typically, you don't see recipes being patented, but this time we're going to talk about that Korean company just recently received a patent on their dumpling. And then the lawsuit breakdown of the week, push to start. I think that's what it's called. Prepare to push. We'll talk about that. We'll actually go through the complaint and I'll give you guys my insight. That's a tough one. That is going to be a tough one. Typically, when we do those kind of live lawsuits or those lawsuits that we read through, it's kind of more or less at least in my opinion, a lot of times it's kind of cut and dry. But this one is a little bit more difficult. I would love to get your guys' thoughts to all these, all these stories that we're going to talk about in the comment section. But we are going to start with the Shark Tank pitch of the week. And again, I just actually did these right before recording this live video. So let me kind of pull it up here. Essence. Now, this is interesting. This is why I tell you guys all the time. You guys have to get into the entrepreneurial game. So Essence, you see here, this is a bull ring or nose ring, I should say. I call them bull rings, but this is a nose ring. However, it's a diffuser. So let me hopefully see if I can kind of get some of this stuff off the screen here. So the gentleman again, this is why entrepreneurship is so important. So it's 3 members to this team. It's 3 owners or co-founders, I should say. The one guy, he was on a business trip to Dallas, and I would imagine that a lot of us have experienced this. Thankfully, I have not experienced this. He was on on an airplane next to somebody who wasn't smelling so good. And look, as opposed to just kind of getting to Dallas or getting back to wherever he's from and kind of telling his family or friends, hey man, I was around somebody who stinks. He was like, damn it, I'm going to do something about it. And that means I'm going to come out with a product so that people can use when they face similar situations. And that's what he did. And this nose ring, which again, everybody's wearing them anyway. I don't go a day without men and women running across men and women that has some, at least one or a few men and women per day wearing these kind of bull rings or these nose rings anyway. So he has maybe a nose ring that you can wear that kind of diffuses a scent, a nasal scent. You see here, stress relief blend. This is a eucalyptic. I think he has a lavender immunity blend. So he has a lot of different blends, or the company has, and you can wear it whether you're on an airplane. And next thing you know, you don't have to have that stinky smell of that person next to you. And at the same time, you don't have to offend them. So I love this product. It was a couple other products of the pitches that I thought were pretty cool. 3 out of the 4 pitches got an offer and got a deal. However, this Essence one I think is going to be it's going to be around for a long time, just because, again, they were already making, as of 2024, look, they started the company in 2023. They made $350,000. And the following year, they made $750,000 in revenue, of which $100,000 that they profited. And 30% was DTC, direct to consumers. Seems like they're expanding the market, because I was initially, as I was doing the breakdown in real time, I was just thinking like, man, what are going to be the use case scenarios, or what is this going to be applied to? Okay, we got the airplane situation, but am I buying something just to get used on an airplane all the time? But as they started kind of going through the pitch, it was like, oh, I see it. I see you can use this thing. Spas, they're using it in hotels. This is something that they're talking about using it in hotels. Then I even love it for college campuses. When you are coming in with as an incoming freshman, you're in the dorm room. Sometimes, hey, that roommate, they hygiene is not where it needs to be, and kind of having these as like a gift package, part of that kind of give back that they give you. I think this is another thing that can be big on college campuses, universities across the country. So, man, I love the product, and it kind of turned into a bidding war. They ultimately did a deal with. Who did they did a deal with? Damon. It seems like Damon is involved in some of everything. It seems like he has already an aroma company that's kind of doing millions of dollars in sales a year, and it seems like that's who they got to deal with, and they kind of wanted to deal with Damon. So shouts out to them. Hey, I love the product, and not only do I love the product, I love the fact that how they came for the product to be. They weren't kind of experts in aromatherapy or in kind of nose rings, anything like that. They saw a problem, that being, hey, and the problem that one of them was going through personally, of kind of being next to somebody on the plane that was stinking, and they did something about it. They came up with a product, a nose scent ring that kind of diffuses noses or diffuses a scent as you can breathe in it, and you can do it without offending anyone. And again, it kind of blends in. It looks like a nose ring anyway, which a lot of people are wearing. So shouts out to Essence Diffusers, the company. I think they have a pretty good thing going on here. So shouts out to them. So the interview of the week, Dr. B Elixir. Now I'm going to play the YouTube video. Let me kind of get that queued up for you guys. But this essentially is a product that queued up here. It's a mouth spray. So, again, the interview dropped this week. It's essentially a mouth spray where you, again, if you're eating something hot, I remember it was a couple years. It had to be like 8-9 years ago now. I was at Buffalo Wild Wings, and I got like the hot wings, or like supposedly hot wings. But, man, these guys had to give me the hottest wing that they had. I'm eating this thing, and I was drinking a glass of water after each wing. And I was pretty frustrated that day. But Dr. B, has created something, a mouth spray that if you eat something hot and spray it, that kind of, you still get the heat, but that kind of painful sensation kind of goes away. So he has found something out, or got the right mix to be able to kind of deal with that. Let's kind of take a look at it. And again, this is going to be the intro of the interview. So let's see what he says about the product, and then let me make sure it's on normal. Yep, okay, it's on normal speed. Sometimes I listen to these things on 2x, but let's see what he says about the product, and go from there. Let's go.
One of the things also I wanted to try to make the important point of why people should get a hold of somebody like you. So when I first invented this, the mouth pain from eating spicy food was the only thing I was thinking about. So if I were to fill out my first patent and say, hey, it helps eliminate the pain from eating spicy food, what did I leave out of my patent? All the other areas of where it could be of benefit to. And so my short-sightedness and not seeing a broader picture could very much have hindered my ability to get the proper protection. So knowing, if somebody said, hey, we would really like to buy your spray from you, let's take this off your hands. We've been listening to the Dave show here, and you know what, we have that supply chain. Let us get that off your hands, and we'll get that out in the market. We'll maybe give you a.
So there you go, man. There you go. He essentially was talking about how the importance of, as I kind of bring it back on myself, the importance of having a good IP counsel. Because whether you're writing the patent or whatever the case may be, you don't want to limit your invention to a particular area. I just talked about with the nasal diffuser, which I'm hoping that they have definitely a design patent on, not even a utility patent. I think they have a good chance of getting that. But sometimes if you don't have a good patent attorney, or you try to do it yourself, a lot of times you can kind of limit the scope of this thing or limit the protection of it. But when you have a good patent attorney, they're going to be able to, or a good IP attorney, they're going to be able to kind of cast a wide net, so to speak, so that these other different uses you can still be protected in. I just talked about with the nasal diffuser. Again, they started out with airplanes. Next thing you know, they're using these things in massage spas. They're using these things in hotels, and I'm talking about potentially using it for a university. So you don't want to kind of limit the uses of it. And a good patent attorney is going to be able to write the patent application or draft the trademark application or the copyright application or whatever the case may be, such that you can be protected in multiple areas. So again, great interview with Dr. B Elixir. He's doing some great things with this mouth spray. Go check out that full interview on the YouTube page, as well as you can kind of check it out on podcasts, Apple Podcasts, Spotify, wherever you listen to your podcast. Go check out that. I thought it was a phenomenal interview, and I thought it was, I thought he had some good information about, hey, a good patent attorney. Actually, I did an interview yesterday with Riverbend Resources, which is another Shark Tank product that's going to be coming out probably in 3 or 4 weeks. But he kind of had talked about how, man, he had 3 patent attorneys, and typically as a patent attorney, when somebody comes in and say, hey, this is my 3rd or 4th patent attorney, you kind of get a little hesitant. Are you not paying them? Are you difficult to work with? I'm trying to think, why is this guy had 3 or 4 patent attorneys? But it seems like the earlier patent attorneys he's had were maybe not as good, unfortunately, and kind of put him behind the 8 ball. So he talked about how good a patent attorney is worth the worth the way to go, however that saying goes. And so that you want to make sure you have a good IP attorney out here kind of doing your work. So shouts out to Dr. B for his amazing product. Let's kind of move on to the next. Let's move on to the next thing. So, man, somebody had reached out to me, or they left a comment on this video. So, or on a video that I did on a Korean dumpling. So this is a story about Bibigo. I'm not going to pronounce that. Sila Ji Dang. It's a Korean company, but they got a U.S. patent on their product. I'm not going to go through the article again. I already did the long form video that came out yesterday on that. So go check out that video. But somebody left a comment under that video to say, hey, because I initially said it was a Chinese company, because the article, it kind of talked about this being in a Chinese media scene. And what's the name? The comment said, hey, this is a Korean company, unless you're trying to say that China owns Korea. I'm like, man, number one, thanks for the clarification. But 2, hey, man, that's a disingenuous of you to try to make this thing be a political thing, which clearly it was not meant to be that. And then the person kind of responded saying that, hey, well, you could have looked at the Chinese letters and saw that this was a Korean company. And I guess to that I'll say, and because I didn't respond, but to that I'll say this: if you think that me as an American-born citizen is looking at these characters and saying, you know what, that's not Mandarin, that's Korean font, you have another thing coming. Like, I know English, I can tell maybe some Spanish or some French, maybe some Germany, but I'm not looking at the distinction between Mandarin and Korean and saying, oh, that's Korean, that's not Chinese, so therefore it has to be a Korean company. I don't know, man. The nerve of people sometimes. But nonetheless, this Korean dumpling company, I thought this was surprising, because a lot of times with food companies, and we see it on Shark Tank, and I've done reaction videos and videos to it, you typically keep these as a trade secret, which you should still have a trade secret on the actual food recipe, to the extent that it is novel and new or unique. But this one was interesting because they also got a design patent on it. Now let me see if I can kind of roll down here and see if I can so it's not shown in this one, but this typically your dumplings are like, has this kind of is long. It's kind of, the dumpling is long. I'm pretty sure you guys have seen a dumpling before, but their dumplings has like a circular shape, so which is different from traditional dumplings. So not only, I'm assuming that they do got a trade secret on it, but in this article, they saying that, hey, this company also got a U.S. patent. And that particular patent, typically you have a utility patent and a design patent. You also can have a plant patent, but we typically don't talk about those because those are kind of far and few in between. But a utility patent protects the functionality of something, whereas a design patent protects the visual appearance. The ornamental use of it is what we call, or the ornamental look of it is what we call. So they actually got a design patent on the visual appearance of the dumpling, because it is circular as opposed to that traditional dumpling that's kind of more so longer. So again, trying to give good information for you guys, to the extent that you have a product that you may be getting a utility patent on, or keeping it as a trade secret, be sure to look to get this thing, keep this thing as a design patent to protect that ornamental feature of it. I actually had talked about that with the essence when I did that reaction video, to say, okay, a design patent maybe is a must because it's a diffuser, but you typically don't see those diffuser in that kind of nose ring shape. So again, whether or not you can get a utility patent on it, you have to go through the process and see. But I definitely haven't seen anything like this from a design patent world. So I would definitely hope that they protected this thing via a design patent. And again, similar as the dumplings here. Dumplings are a different shape or ornamental kind of visual appearance typically, and they have a dumpling that is more circular, which is different from that traditional shape. They got a U.S. patent on it, so shouts out to Bibigo for protecting their IP. Shouts out to them, man. That's good stuff. That's good stuff. Let's move on to the next one. Your boy Migos. Boy Migos got in some trouble, or Quavo, I should say. Quavo from the group Migos. Hey, does Migos still kind of operate under that what's the name since the untimely death of Takeoff? That's an interesting question that I'm interested in knowing the answer to that question. But let me pull it up here. Takeoff. He was sued for copyright infringement based on this sculpture. So a gentleman, and it seems like this artist, if you will, he is a pretty well-known artist in that New York area, at least according to the article. And I did a reaction video that was like 10, 11 minutes long, so definitely go check out that. This is kind of more of a quick recap. He did a reaction. I mean, he has worked with this artist in New York, some big dogs. He worked with Jay-Z, he worked with Pharrell. I think the article said he also worked with Usher. And so he sculpted this car. And the good thing about that is it's a copyright. So for those of you who don't know, you can get a copyright on a number of things. Typically, you see, okay, a book is a copyright, a picture is a copyright, a 2D picture. Typically, you see music, whether it's the beat, whether it's the song, the lyrics, that's a copyright. The TV shows, your movies is a copyright. But you can also get a copyright on what we call a 3D work. You guys may know it as a sculpture. So this is actually the sculpture that the artist kind of sculpted, and obviously he got a copyright on it. And it seems like it was a picture taken, and Quavo posted that picture on his TikTok, on his Instagram, and pretty much said, hey, he did it in the sense that he was like almost promoting music because he was posting it along with music. And that's kind of a big no-no just because it seems like you're trying to use the car to try to help out your commercial earnings or commercial potential. Now, if you're just kind of posting this car and hey, say it's sweet, then that's one thing. But when you're posting this in addition, along with your music that you're posting, then that can be looked at, or you're trying to use it for monetary gains or to promote something for monetary gains. And that's kind of a tougher sell at that point in terms of it being fair use. Now, it'd be interesting on whether or not he tries to claim fair use. I think they also sue not only Quavo, but QC Quality Control, which I think is the label that he's signed to. But again, when you're trying to post something and it is an exact replica of a copyrighted work for monetary gains, then it's going to be tough for you to kind of get away with that. So it seems like in this case, the artist actually sued Quavo for copyright infringement. We'll see how this kind of plays out. But the big thing that I did want to take away is the derivative works. Like I said, that original work, the sculptor, the car sculpted, that's that original work. But as a copyright owner, you also have ownership in exclusive rights to derivative works, whether it's the right to distribute something. Again, so for example, if somebody takes that sculpted work and takes a picture of it and they want to kind of sell that picture, they have to get permission from the original owner of the copyright, or in this case, the original owner of the sculpted car, because that picture, that 2D picture that they took, that's a derivative work that, again, the copyright owners, the original copyright owner still can kind of deal with or make what's the word that I'm looking for? He can control how it's distributed. That's a good way to put it. And again, it works with Hamilton. So, I mean, I love the stage play Hamilton, but Hamilton, again, it's a musical play, a Broadway play, but they actually gave the right to be able to distribute the play in its kind of video form to Disney for like $75 million. So that's kind of shows the value of the derivative work. And you can kind of carve out where you can give ownership to or license a portion of your derivative works. In this case, say a 2D picture or the 2D picture for somebody, for a fee, while you're still kind of keeping the ownership of the original work. So the big part of copyright, or an important part of copyright that's not talked about a lot, is the fact that you own these derivative works, the right to distribute, the right to copy, to make copies, these different things that you can sell for money based off of an original work. It'd be interesting to see what the court says with Quavo. I would imagine that this, like most cases, gets settled out, but to the extent that it goes to a jury, Quavo may be in some trouble here. So that's just my take. I'll be interested to see what you guys think about it. Let's kind of move on here. Your boy Bill Belichick. I'll tell you what, man. Bill Belichick is living the good life. So you can see Bill Belichick here with his young thing. I think her name is Jordan Hudson. You see the picture of her. Hey, man, she looks pretty nice, man. Bill Belichick got even a good one. But so again, Bill Belichick, for those of you who don't know, former New England Patriots coach, head coach, obviously won 6 Super Bowls with Tom Brady as a quarterback with New England Patriots. A couple years ago, it seems like the New England Patriots fired him. It seemed like it was time for a new start. And he recently, I think, just became the head coach of the North Carolina Tar Heels. So he's in the college recruiting ranks. So it'll be interesting to see how that plays out for your boy Bill. But it seems like, again, Bill 72 has got with a young tenor thing, 24 years old. That's crazy. This girl is 3 times, or Bill is 3 times the age of this girl. He's 72, she's 24. And she looks good. And it seems like they have started a company together, and they filed for a number of trademarks. 2 of those trademarks, No Days Off and Ignore the Noise, was created by Bill, but it was created by Bill while he was with the New England Patriots. And actually, the New England Patriots own the trademarks for them. So you see the article here. Jordan Hudson filed trademarks for a boyfriend Bill Belichick's version of the phrases that Robert Kraft owns. So Robert Kraft and the New England Patriots own these phrases. And this is why I always tell you guys, it's important to file for these trademarks sooner rather than later. Seems like Bill Belichick used these phrases, and New England Patriots Robert Kraft saw the potential in them, and they looked at it from a business standpoint, filed for trademark protection on it, and they own them. So now Bill Belichick is trying to use a playbook out of Taylor Swift's page out of Taylor Swift's playbook to get the ownership back. And I can tell you as an IP attorney, he's not going to make it. So typically in copyrights, it's a clawback provision. So you can get that. So for example, say you made music for a company, the company owns the music. You can kind of get that back after a certain amount of time, which is called the clawback. In this case, Taylor Swift, she actually, and I think Ashanti did the same thing where they re-recorded the music, and now they can't do anything with the original music, but that re-recorded music, they got ownership in and they can sell and things like that. And that's essentially what Taylor Swift did. But again, that's copyright law. In trademarks, you can't do that. So it seems like Bill Belichick's girlfriend, Jordan Hudson, tried to do a similar thing with filing trademarks and put Bill's version at the end of it, thinking that that's going to kind of help her case for being able to get it back. And I can tell you as an IP attorney, that is not going to work. Again, copyright law, trademark law is completely 2 different things. And to the extent that somebody owns the copyright, the trademark to something, you file for it and it's a likelihood of confusion, then you're not going to be able to get the trademark and you can potentially open yourself up for a lawsuit. So I can guarantee you guys, Bill Belichick and his girlfriend, his young hot tenor thing will not get a trademark on this Ignore the Noise and No Days Off that's owned by Robert Kraft and New England Patriots. But this actually kind of leads to another point. I thought everything was kind of, at least on kind of speaking terms between Bill Belichick and Robert Kraft. And I would imagine that this kind of blows any of that up to the extent that they were on good terms. I would imagine that Robert Kraft and the New England Patriots can take offense to this. And yeah, that's that. But shouts out to Bill nonetheless, man. He got him a nice little thing. He has him a nice little thing. So I do want to kind of get off into the lawsuit of the week. And this is an interesting one. So you see here on the screen, let me see if I don't have the, I'm not going to put up the lawsuit yet, but I'm going to just kind of explain to you guys what's going on. So this prepare to push. So just let me kind of take it away from them right now. So say you have Delta, the airline company that's providing a service for kind of airline flights. And then you have Delta, say the faucet company that is selling faucets. Clearly, those are 2 different industry, appliance industry compared to the airline industry. One is essentially conducted in a service, that being the airline industry, Delta Airlines, whereas Delta, the faucet company, is selling a product, that being the faucet. So clearly there's no, even though it's the same name, it's not a likelihood of confusion because they're really in the different technology areas. And when they both want to go file their trademarks, and both of them, those companies, Delta Faucet as well as Delta Airlines, have registered trademarks on their on their logos and their names in different classes. They're again completely different industries. But now let's just say hypothetically, Delta Faucets start selling airplane toys under the term Delta. Is that a trademark infringement? Is that likelihood of confusion? That's a real question, because that's what we have in this case. Like I said, it's easy for the case where you have Delta Airlines that's kind of essentially selling a service for airline flights, and then you have Delta Faucets that's selling a faucet, completely different area, although it's the same name. But if Delta Faucets starts selling planes, so toy planes under the term Delta, is that a likelihood of confusion? It gets a little closer. I think even though Delta Airlines is not selling airline toys under the term Delta, it's still kind of in that same industry. So the class may be different. One is kind of selling the service, airline flights. One is selling toys, but the industries are essentially the same, that being airplanes. So I think that's kind of closer to trademark infringement at that point, and that's essentially what we have here. So you see the prepare to push. You have a company that's suing actually the wine company. So the picture you're seeing to the left, that's a wine that I'm assuming that is helping out with somebody, a mom giving birth. But she has a trademark, or I think she recently filed for a trademark on the term prepare to push, whereas it's another company, the plaintiff, the person who's suing the wine company, has educational services going towards teaching mothers to be about pregnancy and giving birth and all those things, and they actually have the registered name prepare to push. So like I said, in this case, even though the classes are different, one is selling an actual physical product, that being the wine, the pregnancy wine, and then the other is selling more of a service, educational service, educating moms to be on, kind of like I said, being pregnant as well as childbirth. However, the name is identical, prepare to push, and it's kind of in the same industry, that being kind of birthing and pregnancy. So is it a likelihood of confusion or a trademark infringement such that the wine company is on the hook for kind of having to pay money out to the educational service company? That's kind of what we're talking about today. Let me kind of pull up here the lawsuit so we can go through it really quickly. It's not as long of a lawsuit, but I think it's a good one. So let me see if I can is this it? Is this it? Okay, this is it. Let me get rid of this. We're going to read this really quickly, and I'll love to get you guys' thoughts in the comment section. So Lord Nance versus, is it Frida Baby? Frida Baby. I guess that's Frida Baby, going towards the whole Free the Baby. I like the name, though. That's pretty a cool name. So Lord Nance has the educational service, and Frida Baby has the wine product that I showed on the screen here. So let's kind of get off to a plaintiff. Lord Nance is an individual residing in Charlotte, North Carolina. Frida Baby is a Delaware company with its principal place of business in Miami. Let's go to the factual background. Plaintiff is the owner and educator at Lauren Nance Education and Coaching, a North Carolina LLC that provides a variety of services related to childbirth and family support. Plaintiff has worked as a doula. I don't know what a doula is. I'm assuming that's somebody that helps with childbirthing for over 20 years. So she got some time in the game and currently serves as a postpartum doula, a lactation educator, counselor, new parent educator, parental fitness instructor, and sleep educator. So she's heavily involved, but after 20 years, that's not surprising. Plaintiff is the owner of the common law rights and the service mark Prepare to Push. Since at least early as October of 2014, plaintiff and her predecessor and interest have used the Prepare to Push mark in connection with services related to the childbirth and family support, which is interesting. So paragraph 10, let me kind of back it up here. Paragraph 10 is potentially saying, essentially saying, hey, she actually got this mark from somebody else. That's what they're saying. Hey, her and her predecessor and interest. Let me see if I can actually kind of go to the mark here. Let me see if I can add it there. Maybe it's at the end. Oh, no, let me see here. I think it's in one of the oh man, there's so many tabs open I have. This is not what I'm looking for. This is a 1.2 PDF. Let me see if I can get to it. I'm pretty close. Okay, here we go. So what I have on the screen here is essentially the assignment. So assignment at the patent office is Exhibit 2 between this. So if you see here, the receiving party is the plaintiff in this case, Laura Nance out of North Carolina, and the mark that was assigned, which prepared to push, which is the mark at issue. You see the registration number, and this is the person who assigned it to her, Kim Boatney, and this actually is a person out of British Columbia. You see the address, Ravine Drive. This is Port Moody out of British Columbia. So this person seems like was abroad, filed for a U.S. trademark back in the day, and as of 2023, she assigned it to our girl Laura here. So that's essentially what that part of the lawsuit was saying. Let me kind of pull back up the lawsuit when they were talking about the fact that Laura and her predecessor had been using this mark, I think, since October 2014. So again, as you saw in the what's the name, that mark was just assigned to Laura in 2023, but seems like her predecessor, Kim, out of British Columbia, was using it as early as 2014. Plaintiff acquired by assignment, prepared to push trademark. That's essentially what I just saw showed in Exhibit 2. Through plaintiff's long-standing and continuous use of the prepare to push mark, this mark has developed invaluable goodwill. Plaintiff is the owner of the U.S. trademark registration, which I just showed, which registration issued in October of 2019 from the application filed in 2018. And it kind of recites education services, namely providing live and online classes, seminars, workshops, and training programs in the field of prenatal and postnatal fitness and wellness for women, education services, namely developing, arranging, and conducting educational conferences and programs and providing courses. So pretty much education. A true copy of, I'm not going to pull up that. Let's go to 14 here. Plaintiff registration is a valid and subsistent in law, was duly and legally issued, and constitutes a prima facie evidence of the validity of the registered prepare to push mark, and the corresponding plaintiff's registration of plaintiff's ownership of the registered prepare to push mark, and of plaintiff's exclusive rights to the use of mark. Essentially, they're saying that they have a registered mark here. Let's go to 16. Is this something that's interesting? I don't know. Really, let's go to the defendant's business and infringement activity. So this is where we start getting good. On information and belief, defendant describes itself as a business that works to make tackling the not so long glamorous aspects of parenting a little bit easier, from pregnancy pains in the bump to potty training troubles. They deal with potty training. Defendants uses the mark prepare to push in connection with the sale, offering for sale, distribution, and or advertising of a perennial massage wand that helps pregnant women ace the stress rehearsal to reduce your risk of tearing down delivery and impacting your postpartum recovery. Which again, this is why this one is so close, because one is educational services, the other is an actual wand, a physical product. And as I gave an example of the Delta thing, it's one thing if the industries were completely different, but they're both dealing with a different product, and therefore you're protecting the mark prepare to push in different classes, but it's the exact same name, prepare to push, in the same industry. That makes it a little bit more interesting to me, and to be honest with you, I think it makes it a little bit more like trademark infringement if I had to guess. But I would love to hear from you guys in the comment section, so please leave your thoughts in the comment section, and to the extent that you've used this wine or used this service, let me know how you like that as well. So let's move on to 19. Defendant uses defendant's infringing marks on his website as well as social media posts. So it's essentially talking about the prepare to push. Obviously, you see the prepare to push name. You see the wine there. I actually showed that wine as well. We got Freedom Mom. It isn't this type of wine. It isn't that type of wine. Our prepare to push massage wine helps mom prepare for the home stretch starting around 34 weeks. You don't insert. Wow. So I guess they thought that you insert that thing in that thing. But instead you use it to gently massage and stretch the perineal skin to help preventing tearing delivery or during delivery. It's the perfect length to make reaching around your bump easy. It comes with a mirror so you can see exactly what you're doing down there. That's pretty sweet. So I guess some people thought that you had to put that thing in that thing, but they said that's not the case. I'm not sure why they put this portion of it in a complaint. But nonetheless, on information, I believe defendant has used defendant's mark in North Carolina. So it seems like she's selling that to at least people in North Carolina. Defendant filed an application. So she actually filed for protection on prepare to push with the United States Patent and Trademark Office. And as I talked about before, it's not uncommon for people to get the same name registered in different classes in different areas. But if it's the same name in a different class in the same industry, is that not only trademark infringement, but will Free the Baby actually even get the trademark to prepare to push? Because you can still get the trademark on prepare to push, and kind of the plaintiff in this case, Laura, can still try to sue you for trademark infringement and petition with the USPTO and, of course, to cancel your mark. So just because you get a trademark, that doesn't necessarily mean you're kind of out of the clear, so to speak, but it at least shows you that at least the examiner at the USPTO did not think it was a likelihood of confusion, which can kind of help you in the case. So those are kind of my thoughts on that. Let's kind of get back to the lawsuit and see what they're saying here. So defendant's infringement mark is identical. I would agree with that. Defendant's goods are similar to and overlap with or related to plaintiff services. I think the industry is the same. I think the goods are different. One is a wine to help kind of massage the skin, to help with delivery. Another is just kind of providing educational services. So I do think the goods are different. I think the industry is the same. And I think with the industry being, if the industries were different, this is not a problem. But with the industries being the same, I think that kind of hurts Free the Baby, the defendant, in my personal opinion. But I would love to hear your guys' thoughts. Let's move on to 24. On information of belief, defendant services and or are expected to be marketed to similar, if not the same consumer. I would agree with that. I would agree with that. So let's go to the related proceedings on February 5th. So a couple months ago, seems like Laura initiated opposition against defendant at the TTAB, Trademark Trial and Appeal Board. So pretty much, again, what you can do is when somebody is filing a trademark. So for example, to the extent that Free the Baby did not file for a trademark, Laura, she could not have petitioned to cancel the mark because there was no mark to cancel because she wasn't protecting this, or at least trying to protect it federally. But once Free the Baby filed for a trademark application with the United States Patent and Trademark Office, now Laura, as the plaintiff, who already has a mark that she thinks can be confused with the pending mark, she can petition the the TTAB, the Trademark Trial and Appeal Board, to cancel the trademark application for Free the Baby. So that's essentially what the TTAB is and what is happening in this situation. Hopefully you guys understood that. Upon information and belief during the pendency of the notice of opposition, so it seems like it's pending. Defendant has continued to use the infringement prepare to push mark in connection with the sale, offering for sale, distribution, and or advertising of the massage wands and massage sticks for pregnant women. And again, it's no rule that says while you're pending or while this decision is pending at the TTAB, you have to stop selling your product using the mark. Using a mark, but you are kind of using it at your own, detriment at that point. So again, it's no rule that says you can't continue to use it, but to the extent that you are found liable for, say, trademark infringement or likelihood of confusion, you're kind of opening yourself up for a trademark infringement case. So right now it's not. Well, right now it is a trademark infringement case, but to the extent that this goes all the way to the end and is decided on by a jury or a judge, the damages can be calculated from when that TTAB proceeding has been initiated, especially since she was still kind of using it at that point. And let's finish out with the counts, or at least count one. Plaintiff realleges everything. So plaintiff owns valid and enforceable rights in the prepare to push mark as reflected in plaintiff's registration. We already went over that. They're pretty much saying, hey, defendant has used prepare to push without the consent of the plaintiff. Defendant uses defendant's infringement mark in the geographical territory. Again, man, when you which again, Laura has a nationally registered mark. So regardless, the territory is the United States, even if it wasn't kind of used in North Carolina specifically. There's no issue as a priority of use. Okay, whatever. As a result of the similarity of the parties' marks and the overlapping nature of I don't think it's an overlapping nature of the goods and services. I think the industry is overlapping. The use and concurrent registration of defendants, Free the Baby's infringement mark in connection with the goods prepare to push mark in connection with the plaintiff services is likely to cause confusion. I mean, I think she has a good argument. That's my take on that. I think it was a couple other things that I did want to what's the name. I'm not going to go after the unfair competition as well as the other counts that was in this one, but I did think it was something else that I thought was interesting enough to show you guys. So kind of give me a second on this. We got Exhibit 2. Maybe is this it? So we saw Exhibit 2. That was just the trademark assignment with the USPTO. I think okay, this is just the wine here. So it seems like for $30 you can get a wine that kind of helps you kind of massage that skin. You do not have to stick it up your private area. I think it was one more that I did want to show. And I think it's this right here. We kind of do it. So this is Exhibit 4 that I'm showing, and this essentially is the trademark application of Frida Baby. So this is the one that kind of opened her up to have her trademark application canceled before the USPTO. Again, the marks are the same. Prepare to push. This is a Miami company or operating in Miami. The legal entity is in Delaware. Again, it's a massage stick. So it's not necessarily educational services. This is a massage stick. It seems like a member of the California bar, Amy Abeloff, filed for the trademark application. And kind of pretty much it here. See if there's anything else. Seems like this is the website. So again, you guys have to let me know what you guys think. Like I said, I think that Frida Baby may have kind of stepped in some with this. But again, that's just kind of me based on my experiences. And I thought this was good to talk about because typically we see these kind of trademark infringement cases, copyright cases, patent infringement cases, and they're kind of more so, at least in my opinion, pretty straightforward. Where this one was a little tough. As I gave you the analogy with Delta earlier, to the extent that the industries were different and the names were the same, I think we don't have an issue. The fact that now the industries, the name is the same, the industries are the same, even though the nature of the goods and services are different, one being educational services, the other being an actual massage stick. I think the fact that the actual industry is the same, it makes it a lot more interesting. And I think that she can get a trademark infringement case. I think definitely the market, if I had to guess, I think the market is going to be canceled. And I think that to the extent that she continues to use it, prepare to push, I think, again, this is a lawsuit, so we'll see if she stops using it. But I can see if this goes to a jury or a judge, she can get kind of slapped with trademark infringement. So I'll try to keep up with this one and let you guys know kind of what actually happens in real time. Hopefully you guys enjoyed this one to the extent that you've used to prepare to push educational services or to prepare to push wine. Let us know your uses of it. Hey, look, I tried to look out for the women on this one. I thought this was something that they'd be able to kind of participate in a lot more, especially since it's kind of dealing with a kind of woman product or woman services. Before we get out of here, I do want to plug the ebook, Got IP. This is kind of from getting an idea all the way to monetize your product or your service. This is kind of give you a step-by-step breakdown. It's a lot of cool stories in there from the people that I've interviewed. A lot of those people are or who have been on Shark Tank. So I think it's a phenomenal ebook. I'm going to put it in the description. Please check out the ebook and kind of let me know what you think to the extent that you have got it. It has kind of been selling, which has been pretty cool to see, something that I've created and got a copyright on selling. So shouts out to me for that. Like I said, this will be in the comment section. So please go check it out. Go purchase it. Go let me know what you think of it. So that's all I have here. So again, hey, I was maybe going to just take this week off, but I said I still have to get the people the game, the education, let them know what's going on the IP front. This past week, like I said, we talked about a lot. Dr. B with the elixir. We talked about the Shark Tank pitch of the week with Essence. Talked about the Korean company getting a patent on dumplings and a Quavo from the Migos. Hey, finding yourself in a copyright case. We talked about Bill Belichick and his young thing, maybe ruffling some feathers with Robert Kraft and the New England Patriots. So we have to kind of see how that kind of plays out. And last but not least, the prepare to push trademark and kind of that battle going back and forth. And I gave you my thoughts on what I think is going to happen. We'll see how it plays out. I would love to hear your guys' comments on each of these topics in the comment section. So please do that. And I'll catch you guys next week with a live show. We back live next week. So I'll see you guys with a live show. Hopefully you guys enjoyed your Easter weekend, your holiday weekend. And